This is Barry Zalma speaking for Zalma on Insurance on YouTube. I am an attorney who has retired from the practice of law and now spend my time acting as an insurance claims consultant, an insurance claims expert witness, and author and producer of these YouTube videos. Today we're going to talk about how to negotiate a third-party liability settlement. After the adjuster determines that coverage exists, that the insured is probably liable for causing bodily injury or property damage to a third person, the adjuster must negotiate a settlement with the claimant or the claimant's attorney. Just like the plaintiff's attorney in a personal injury case, the insurance adjuster will investigate the claim, the facts of the accident, and the plaintiff's damages. A very skillful and well-prepared insurance adjuster will often know more about the accident and about the plaintiff's background than the plaintiff's lawyer. The adjuster prepares for making an offer by first getting the insured's story of the accident. This is obtained by completing a thorough recorded statement. The adjuster will then investigate the plaintiff or the claimant. The investigation can be simple as reviewing claims databases compiled by the National Insurance Crime Bureau or the Insurance Services Office, all claims databases that allow adjusters to determine whether the plaintiff has ever filed a personal injury claim before. The thorough adjuster will also search Google, Bing, Ask, Twitter, Facebook, and LinkedIn to learn as much as possible about the plaintiff. Sometimes he'll also learn as much as possible about the plaintiff's lawyer, if he does not already have experience dealing with that particular lawyer. The adjuster must obtain from the plaintiff or the plaintiff's lawyer to introduce himself or herself and request that the plaintiff provide documentation relating to the plaintiff's claim. The adjuster will then review medical records, medical bills, proof of earnings, tax returns, proof of property damage. If the initial medical records indicate that the plaintiff may have had prior injuries or complaints to the body part that was injured in the accident that led to the current claim, a competent adjuster will obtain all prior medical records for any treatment that the plaintiff or claimant has ever had for that condition. If the plaintiff or claimant is self-employed and claims lost earnings, the adjuster will usually request that the plaintiff produce business records to document the lost earnings. The documentation obtained will be reviewed carefully by a competent adjuster. The adjuster should read every page on the medical records and bills to see if anything is missing, if anything suggests that the plaintiff has had prior conditions, or that the plaintiff is malingering, or his lost earnings claim seems to be unsupported. The adjuster should never make a settlement offer or respond to a settlement demand until the adjuster has every document that he or she needs in order to value the case. Once the adjuster has all the claimant's or plaintiff's medical records and bills and all other information that he or she needs to value the case, he or she will, based on experience, knowledge of the local jurisdiction, and experience and knowledge of local jury verdicts for the same type of accident and injury, start the process of finding a value for the claim. In order to value the case, the adjuster has to think about what are the plaintiff's chances of winning at trial. How much might a jury award the plaintiff? How amenable is the claimant and his or her counsel to negotiate a settlement? How much experience does the claimant's lawyer have in trial? How much experience does the adjuster have with the claimant or plaintiff's lawyer? If, for example, the plaintiff has damages that approach $1 million judgment if the jury finds the adjuster's insured liable, but has little if any chance of winning at trial, then adjuster should not offer much to settle. The obverse is also true. If there's a good chance of success at trial, the adjuster and insurer should be prepared to offer a sum close to, but less than, the jury verdict value. Once the adjuster has decided what the plaintiff's chances of winning are, he or she will think about the plaintiff's damage claim. Damages in personal injury cases are usually divided into two categories. Damages capable of exact calculation, medical bills, lost earnings, cost to repair or replace damaged property, and damages not capable of exact calculation, such as pain, suffering, and inconvenience. For medical bills and lost earnings, the adjuster simply adds them up if they are legitimate and presented by a legitimate organization like a hospital. The adjuster recognizes that hospital and physician billings are flexible. If, for example, the plaintiff is on Medicare or Medicaid, the hospital or physician, by contract, charge much less than they charge a person without insurance or on a lien, where the physician agrees to only require payment when the lawsuit is settled or a judgment is issued in favor of the plaintiff. Adjusters with full knowledge of the different amounts charged by healthcare providers will be in a position to honorably discount medical bills if they appear to be soft, meaning that the vast majority of the medical bills come from healthcare providers other than physicians and hospitals. If, for example, a plaintiff had $7,000 of medical bills, but $6,800 of the bills were chiropractic and physical therapy bills, the adjuster will consider it appropriate to reduce the medical bill claim in half or at some other limitation for valuation of settlement purposes. The adjuster should also determine whether the medical bills presented by the insured were paid by a third party like a health insurance, Medicaid, or Medicaid. These entities often pay much less than the amount billed as a result of contracts with healthcare providers. For example, I once dealt with a case where medical bills were presented in excess of $3 million, only to find that the healthcare providers accepted as full payment $200,000 from Medicare. The settlement negotiations changed exponentially when the true amount of medical billing was established, and when it was realized that the medical bills could be resolved by a payment of $200,000 to Medicare. To be recoverable, a medical expense must be both incurred and reasonable. This stated by the California Supreme Court in a case called Howell versus Hamilton Meats and Provisions. Initial medical bills are generally insufficient on their own as a basis for determining the reasonable value of medical services. Cases have held plaintiff who relies solely on evidence of unpaid medical charges will not meet the burden of proving the reasonable value of medical damages with substantial evidence. Once the medical billing and incurred losses are determined, then it is the obligation of the adjuster to determine a value for pain and suffering. This can be a real struggle both for the plaintiff's attorney and for insurance adjusters. Adjusters have the assistance of formulas and specialized software to assign a value to the subjective pain, suffering, and inconvenience claims, but those items of software seldom work with each claim and must be modified by the experience and knowledge of the adjuster. A key component of the bodily injury claim demand made by the claimant are the medical specials, which, as the Howell case made clear, may be inflated and at times unrelated to the claim. Just because the attorney for the plaintiff says so doesn't make it so. In many instances, there are varying degrees of subjectivity in findings. There are also numerous opportunities for billing errors or even intentional billing fraud. Claims adjusters must be aware that there is a high probability that medical bills contained in a bodily injury claim are upcoded or unbundled. It is also possible there are issues pertaining to causation, duration, and frequency of treatment. It is the job of the adjuster to identify these issues and raise questions, often documented with the assistance of third-party medical billing review software or experts. By further leveraging medical experts or those fluent in billing and coding, a tremendous amount of medical inflation can be avoided. By coupling this knowledge with proper liability assessment, the benefit to the insurers and the consumer can be significant. When the bodily injury claim demand is received, the adjuster should review all contents to ensure that they include the necessary documentation to complete the injury evaluation. There should also be a notation of any time limit demand requirements with appropriate action taken to ensure a timely response. Generally, this requirement is met by either tendering an offer, when warranted, or notifying the attorney in writing of additional documentation necessary to complete the injury evaluation. There is no perfect method of valuing and negotiating a personal injury claim or suit. Each must be dealt with individually, and the adjuster must be flexible enough to obtain a settlement that is agreeable to the insured, the plaintiff or claimant, and the lawyer representing the plaintiff or claimant. Negotiating a final settlement is a little like bargaining to buy something at an outdoor market where haggling is commonplace. The adjuster and the claimant, plaintiff or plaintiff's attorney both know roughly how much the damages claim is worth. The adjuster knows the most he or she is willing to pay, and the claimant, plaintiff, or lawyer know the least amount they're willing to take to settle. Neither party to the settlement negotiations know how much the other side is willing to pay or receive. So consider a few typical steps in the settlement dance engaged in by lawyers and adjuster. The plaintiff or claimant asks for a high amount in a written demand letter. The insurance adjuster tells the plaintiff with details why he or she believes the claim can never survive a jury trial and that most of the negligence is on the plaintiff or claimant. The adjuster explains that the claimant's or plaintiff's lengthy physical therapy or chiropractic treatment was unnecessary or excessive. Regardless of the claimant or plaintiff's response, the adjuster makes a low counteroffer to feel out whether there is immediate need to take any settlement amount. The claimant or plaintiff concedes some of the adjuster's argument and changes the demand slightly lower than the one in the original demand letter, and the insurance adjuster increases the company's offer. The claimant or plaintiff either accepts the amount or makes another counter-demand, and the dance continues until there is either an agreement as to a settlement amount or the adjuster and the claimant's attorney cannot agree, and the case goes through to litigation and trial. This article was adapted from my book, The Compact Book of Adjusting liability insurance claims available from Amazon.com as either a Kindle book or a paperback, and can also be obtained through links in my website, zalma.com, by clicking on the link to the insurance claims library. If you found this article or commentary of use, please subscribe to this YouTube channel, and we will continue with further videos as the days go on. Thank you again for your attention.